Cunliffe.
Well, thank you, Mr Chair. Mr Chair, it is customary when rising to take a call, especially one's first call, as this is, in this debate, for the Social Security Commencement of Benefits Amendment Bill, and what a lovely, benign, positive, rosy title that is, to state whether one supports or opposes the legislation. Now, unfortunately, my colleagues and I are not in a position to be able to do that because our support for it is contingent upon the excellent SOP being put forward by Carmel Sepuloni MP, the gist of which is to delay the commencement of the bill to allow all those who have received a benefit between 3 June 1998, when the mistake first arose, until 19 May 2014, which is when the government in the current bill is prepared to restore their rights, to fill in that gap. Now, if the government would assent to do that, Labor will certainly be supporting the bill. But Labor cannot support it without that assent, because to do that would be to deny people their legitimate rights after the courts have found that the government of New Zealand is in an unlawful position, and thus to trammel the dearly and long-held principle that while Parliament is sovereign, no New Zealand government can operate outside the law. And a retrospective law change to fix a 17-year-old blunder being passed through Parliament in urgency without so much as a select committee meeting is a travesty unless it retrospectively restores the right which the government and Parliament in error unlawfully took. So we either fix it, in which case we can live with the truncated process, or we have to remind the current government that this principle is worth fighting for and vote against it. Now, the government is not helping anybody. They're not helping the public of New Zealand. They're not helping the opposition parties who are showing willingness to cooperate under certain circumstances. That's because it's being rushed through in urgency in all stages, and we're going to be here till midnight tonight debating this bill and possibly thereafter. There is no regulatory impact statement attached to the bill. That means that there is no set of alternative policy options put forward and analysed in the normal way. Therefore, there is no argumentation advanced by the government as to what is the best option, sir. And therefore, the public has been denied the usual rigour and thoroughness of policy advice. There is no regulatory impact statement. To make matters worse, no cabinet papers have been released to the public or to the Parliament to show the logic that Cabinet followed in making its decision. The Minister may wish to take a call to explain what the fiscal risk is that the government is concerned about. Surely that can be the only reason for not restoring, as the court has indicated, the full legal rights of New Zealanders since they were inappropriately and mistakenly taken away in 1998 and henceforth. If it is a fiscal risk issue, and if there is a fiscal veto of Carmel Sepuloni's amendment, then at the very least, Minister, take a call, be upfront with New Zealanders. You pride yourself, Minister, on being a rural chap who doesn't mess around with words. Well, just stand up and take it on the chin. Tell us how it is. We're big enough to take it. If you think it's going to cost $200 million to fulfil the High Court's orders, well, tell us. Was that a yes, Minister? Because there are those who think that yes, Minister apparently is a training video for the current government, and the Sir Humphreys are allowed and well, but we won't go there with your guidance, Mr Speaker. So there is no fiscal estimates contained in the bill. We don't know what the fiscal risk is. We don't know what the difference is between the 2014 fix and the 1998 proper fix. And that matters, actually, because we want to know what the government's price is for sacrificing principle here. As I said, there's been no options analysis, so the public can't tell. Why is the government not, and the Minister might wish to answer this, considered an interest component in the payback? Because the time value of money wrongfully expropriated since 1998 would be not inconsiderable, Mr Speaker. Mr Speaker, if I can turn now to several of the clauses of the bill, Mr Speaker.
Carmel Sepuloni.
Oh,
Mr Chair, I've got several